human beings craft to govern
their lives, that medium must be sensitive to the fact that it is dealing with man as a social animal and man as a political animal. It follows, therefore, that that medium must itself be in consonance, must itself accord to the social ethos that human beings have evolved over the years to be able to make sense. And we can go on and go on in reflecting on what examples from our lived reality make this statement a truism. But I've always wondered when I teach these aspects of legal theory, how come that in a society like this one here, it is far much easier for citizens in this locality to break into the nearest police station and steal firearms? It is far much easier for that to happen than for them to break into a homestead of a reputed witch and steal his wares. How do you explain that relationship between human beings and law and order? Because the proclivity for human beings to theft has been there from time immemorial. It does not surprise me that among the 10 commandments that God gave Moses was, thou shalt not steal. God cannot afford to be irrelevant in his prescriptions. He must have been making an edict that was relevant from the very beginning. That he must have studied his own creation and discovered that they had a proclivity towards theft for him to proscribe it. And yet, that tendency of human beings survives up to now. And then we wonder, how come it will be easier for human beings to breach formal instruments of law, which have coercive power, like police power, and break into police stations, or break into homesteads near the police stations and steal, than it is for them to break into a homestead of a reputed thief, a reputed witch in this community and steal. It means that the way human beings respond to law and order surpasses the technical approaches to order that lawyers have managed to craft over the years of trying to engineer or re-engineer society. Let's come back to the phenomenon of law itself. Earlier scholars like Karl Marx also taught us that the phenomenon that we call law itself, forget about it operating in a socio-political environment. Even when you take that phenomenon itself, they argue that it is just as political as the rest of the state. That there is nothing neutral about law. That law is a tool of dominant forces in society. That's quite a democratic ethic, that the majority will have their number. That those who are major in terms of their dominance will have their way. And it follows, therefore, that Karl Marx may have had his own merit in assessing law as just a political tool as the rest of society. Outside the philosophy that has tried to study society generally, and the philosophy that has tried to study the character of law, there is a third limb of philosophy that I also want to reflect on, which will inform the conclusions that I will invite you to possibly agree with if you find them attractive. It is the phenomenon of knowledge itself. There is a philosophical class of people that we call epistemologists. Epistemologists are people who have reflected on how do we generate knowledge? How do we determine knowledge? The most paradoxical question ever asked over the years in philosophy is, when you say you know, how did you know that you know? And that becomes a very enduring question in legal philosophy, because it means we must have a tool of isolating knowledge from nonsense. That when someone speaks in a hall like this and you say, now, what he is speaking is knowledge, and another person speaks on the same thing in this hall, and you say, no, that is nonsense, there must be a tool, there must be a sieve that distinguishes knowledge from nonsense. And where do human beings get knowledge from? Well, I
Not so long ago, I was engaging my students, and we were reflecting on the mind as a source of knowledge. And while we were reflecting on the mind as a source of knowledge, we wondered where exactly the mind is located in our bodies. After 3 hours of introspection and reflections, we didn't build consensus on where the mind is located in our bodies. Human beings say, "to my mind," without telling us with precision where that mind is located. But that's beside the point. To the extent that the application of law entails interpretation of law, and that interpretation of law requires knowledge of that law and knowledge of the relationship between that law and society, it follows that the scientific study of knowledge as a phenomenon is critical to understanding the political nature of law. What people call their knowledge, in essence, is their experience, is what they have had an experience with. The easiest example to use is the example of the old philosopher Galileo Galilei, who came here and told us that the earth was spherical. And all of you know what the church did to him. The church killed him. Because, as far as the church was concerned, God had given us clear knowledge that the world was flat, and we could see. The church had experienced the knowledge of the flatness of the earth. And therefore, this fellow, who was becoming rebellious by telling us other things, had to be subject to the most extreme of punishments by being killed. Many years later, we have discovered that the experience of the church at that time was at best limited, at worst wrong. That the man we killed actually bore better experience. This begs the question for those of us who engage and interpret the law. Is there any such thing as neutral interpretation of the law? Is there any such thing as objective interpretation of the law? Or is the interpretation of the law just as subjective as the subjective experience of the man or woman interpreting the law? There is an American scholar who has reflected on this question in an article under the title, "Judges as Liars." He says that judges derive their legitimacy from an argument that they interpret the law, that they don't make the law. Judges justify this logic because law-making process is a very political process. And judges are supposed to be perceived as neutral arbiters of disputes, applying neutral rules made by a democratic political environment. And yet, judges schooled in the same law school, for example, reach different meanings of the same law. Judges sitting on the same bench, listening to the same advocates, come up with majority decisions and dissenting decisions. Even those who come up with the same decision can write separate opinions, concurring opinions, reaching the same conclusion using a different logic. It tells you that the understanding or the argument by philosophers of old that there was a possibility of such thing as neutral knowledge, objective knowledge, is at best exaggerated. That if you look at knowledge in today's world, you may be more amenable to a persuasion that knowledge itself is substantially subjective to the experience of those who bear that knowledge. And more critically for me is that, as I used to tell my students many years ago, judges are not quasi-human beings. Judges are actual human beings, themselves an emanation of society, themselves holding as diverse views about life as the disputants who come before them to present their disputes. I am not a fan of doing matrimonial disputes, but once in a while I do matrimonial disputes, And one question I ask disputants to matrimonial course is what magic they think judges are going to do to their marriage that their aunts, their uncles, their grandfathers could not do at home. I keep asking disputants that question all the time. What do you think the judge is going to do to your matrimonial dispute that your aunt cannot possibly do, or your uncle cannot possibly do, or your church minister cannot possibly do? I persuade many of them that chances are that the mzee wa kanisa or the mzee wa mtaa has a greater chance of doing justice to their matrimonial cause in comparison to the professional judge that they go before. Because these judges are themselves an emanation of society, coming with just as many prejudices as there are in that society itself. Begging the question I've posed earlier, that being such an emanation of society, can judges be so neutral that their decisions are not polluted by non-legal phenomena? Is it possible to come across a judge who is so logical, so objective, so elevated from the impurities of society that his decisions can be said to be completely unpolluted by impurities? I want to persuade you that my 2 decades of practice at the bar have taught me that judges are just as polluted as the rest of us. Judges are just as political as the rest of us. And I think what will inform many of you is that I've had the rare privilege in life. Life has been gracious to me, that among the many clients I've dealt with in my life, by latest review, I have handled cases of at least 33 judges as my clients by the latest statistic in my office. And therefore I have sat with them now as clients, as litigants, and listened to them. I have come to the inevitable conclusion that the people I'm listening to are not angels. They are practical human beings with flesh and blood flowing through their veins. And therefore, again, the obsession that perhaps common law trained lawyers have, that disputes must be taken to court, because that is where we are going to have an objective interpretation of law, is exaggerated. The best we get from courts is legitimate interpretations of law. That the courts have an aura of legitimacy, that as a such we have agreed that is okay, because we are all political beings, let us have one among us who, when he speaks, we then can go away saying, it's okay, I may not agree, but he's a judge who has spoken. So the thing that takes us to court is not necessarily objectivity beyond what we know in the rest of society. It is objectivity that enjoys legitimacy. Objectivity that has an imprimatur of legitimacy. Which then begs the question, being an emanation of society like the rest of us, do judges do politics? Do judges engage in politics? Obviously, if a judge was sitting in this audience, he or she would be extremely disappointed if they had me reach the conclusion that I'm about to reach, that yes, judges do politics. Because judges gain their legitimacy from the fiction that they are above the fray of politics, that they are beyond the heat and dust of politics, that judges, core judges, are objective arbiters of disputes and objective interpreters of the law established. In fact, if you walk through many of our courtrooms, you visit the court, even the way the place where the judge sits is designed architecturally is to lift him up above the rest of us, to symbolically create an impression that as the rest of us are fighting down here, the dust from that fight will not cloud the judge's eye. He's beyond these fights. I have made an earlier argument that judges are an emanation of society. I have also made another earlier argument that judges use their knowledge of law and their knowledge of society to sustain their legitimacy. And yet I have made a major premised argument that knowledge itself is not value neutral. knowledge itself is value laden, and that the baggage of values that we carry with us like a hump on a camel's back is synonymous to our unique experiences. What were our early childhood exposures? What were our upbringing exposures? And what residue of impurities have those exposures left in us? Those things keep weighing heavily on us as we get along. Let me give you a few cases, a few examples of cases that have come before our courts, which will then show you that judges are just as political as society itself. If you look at the case of the NGO's board versus Eric Gitari, which is a simple case on the question whether the NGO's board can decline to register an ungovernmental organization whose mission is to foster the mainstreaming of what is now being called LGBTQ rights. And you look at the jurisprudence of the Court of Appeal and you ask the question, look at the identities of the judges who take the view that the NGO's board was wrong, and you will discover that historically they have a background in social rights activism. Are we presuming that sitting on this bench, there are such objective interpreters of our NGO's coordination law as it was then, on the one hand, the penal code on the other hand, and the constitution on the other? Or are they carrying with them the baggage of the activism that has informed their earlier life and which has refused to leave them? When you look at the dissenting judgment of Justice Mohammed Ibrahim, you then ask the question, we all know the position of Islam on this LGBT question. Is he sitting as an objective judge on this question divorced from any extraneous consideration? Or is he carrying the baggage of his Islamic teachings, Islamic learnings, Islamic faith as he sits on that bench? That is how I reflect on this question of the interplay between law and politics. To the extent that it is impossible for me, sitting as an observer with my own impurities, to see that these judges are removed from that background of theirs as they make these decisions, I reach the inevitable conclusion that judges are invariably doing politics, particularly when they engage in politically sensitive cases. That judges wittingly or unwittingly tend to look over their shoulders to ask, and how is our decision likely to be received by the general public as they make their decision one way or the other. Allow me to make just one more justification for this argument I have made before I move to the next limb of my argument. Judges claim that when they make their decisions, they take into account something called the public interest. And that this phenomenon called the public interest is not something over which they conduct a miniature referendum very fast to ascertain. They say sitting in the courtrooms where they sit, exercising their learning and their experience as men and women of the law, they are able to look at the public and ascertain the interest of that public. I have made out a case that just as politicians clothe their individual political interests and claim they are speaking for the Mwananchi, judges oftentimes, in taking into account the so-called public interest, it is public interest in their perception as members of the public in their own right. Because let's not forget that a judge is not removed from society. I've argued elsewhere that no appointing authority goes to the skies and comes back riding on a mosquito with judges. Appointing authorities look among us and pick some men and women whom they think are judicious enough from this society. Sometimes the appointing authorities call upon to remove some of them from the bench, having tested them and found that they were wrong in assessing them to be judicious. Two African scholars have reflected on this question of whether judges do politics. I will reflect on the writings of Chief Justice Emeritus Professor Willie Mutunga and a professor at Makerere University, Professor Oloka Onyango. I was privileged to have been one of the respondents to Professor Oloka Onyango's book on whether judges do politics, or judges and politics. And I have been privileged to have worked with Professor Willie Mutunga, because we both teach at the Kabarak University School of Law, and therefore I've had a chance to test his thinking on this subject. Both CJ Emeritus Willie Mutunga and Professor Oloka Onyango have agreed that judges do politics. And they have reflected on a number of case studies that give them this conclusion. One of them is the prescriptions in Articles 20 and 24 of the Constitution on our Bill of Rights chapter of the Constitution. Our Bill of Rights chapter of the Constitution tells the judges, mandates the judges that as they enforce rights, they must develop the law. They must develop the law. And I had a chance to litigate a matter involving that provision of the Constitution, and one of the questions I reflect on before Justice Mumbi Ngugi was, using what tools will a judge develop the law? Can a judge rewrite the law? If a judge can rewrite the law, then how does the rewritten text find its way in the statute book? And I did some comparative study from South Africa, from Canada, and from Hong Kong to persuade the judge, and the judges from the High Court, the Court of Appeal, and the Supreme Court agreed that there's a tool in interpretation of the Constitution that is called reading in. That a judge sitting as an enforcer of rights can read into a statute some words. And the Office of the Attorney General was at pains to understand what I was saying, because they kept saying, I am asking the judges to amend the statute. I said, no, I'm saying the statute will remain as it is. But as you read that statute, you must see some words there that are not there. That's what I call reading in. You must read into this statute some words in order to make this statute consistent with, then we are looking at Article 27 of the Constitution. And I kept saying that the dominant tool of testing constitutionality of statutes is by striking down statutes, where we find that the statutes are violative of the Constitution. But I kept asking the judges, what do we do with cases where we are saying the statute was on the path of complying with the Constitution, but it stopped short of? So we are not saying it is inconsistent with. It was consistent with, but it stopped short of the full expectation of the Constitution. I told them the remedy in those circumstances is to read in words for the statute to complete that journey it had begun of complying with the Constitution. One may call it the craft of an advocate. Definitely that person will be right. I can assure you, as advocates, doing our duty of representing our clients' interests, we engage in significant gymnastics to try and read, reread, overread the law to ensure that we achieve the ends that we want to achieve. Sometimes judges agree with us. Whether they agree with us to the ends of justice, or whether they agree with us to the greater harm of society, I trust eventually society will judge us when it is placing our contributions on the scales of assessment. Professor Oloka Onyango, on the other hand, has reflected on the questions on whether judges do politics by asking the question, how can judges enforce socio-economic rights without doing politics? Socio-economic rights, by their nature, are resource sensitive. And there is something that we call the lock-on effect of resources. This is how it works. A citizen can go to a court of law and tell the court of law to make a finding that the failure of the Kisii County government to supply adequate water to Kisii University is a violation of Article 43 rights. That's a legitimate argument, particularly if you come across here and you discover that you don't have enough water to flush toilets. That may present a dignity question, isn't it? In many of our public universities and private universities, there is the toilet bowl and the cistern, but there is a bucket in the common area, so that the designer of the toilet knew that the water was supposed to be in the cistern, but invariably the cistern has no water. So to ameliorate the situation, there is a bucket and something to fetch water with. And the whole exercise is undignifying to the user of a toilet. So if you present that question to court, the Kisii County government may come and say, it's okay, you know, we have no problem giving water to Kisii University in adequate quantities, but our capacity to give water to Kisii University will impair our capacity to supply water to another slum nearby. Because the resources are the same. We would have to divert the resources of that slum so as supply water to this university. Or our capacity to supply water to Kisii University will impair our capacity to sustain the school feeding program of kindergarten children in our kindergartens in Kisii County. That's how resources work. But the Constitution empowers courts to enforce socioeconomic rights. It follows, therefore, that courts will engage in the business of allocation and reallocation of resources. Ordinarily, those were questions not in the domain of lawyers, from whom judges are derived. And I don't know about your experience. My experience with the lawyers is that there are men and women who studied law because mathematics was not their forte. They were looking for a course that didn't demand a lot of mathematics. Now, they sit as judges, and they must engage in this business of allocation and reallocation of resources, business that we had hitherto left to mathematicians and economists to engage with, and to an extent, politicians as people's representatives who will engage in a political bargain to be able to give and take and see what to allocate. Professor Oloko Nyango has reasoned that to the extent that we have seen health rights issues, we have seen food rights issues, we have seen water rights issues finding their way to the courts, and courts being called upon to pronounce themselves on that question, judges cannot possibly enforce those provisions of the Constitution without making a political preference of their own over the political preference that the existing executive had made, whether it be the governor and his government or the president and his government. To that extent, therefore, judges do politics. What do we do as lawyers, therefore, on this understanding that there is a close nexus between law and politics? My first challenge goes to university law schools. There were days when we taught law in university law schools as if law was an end in itself, as if law was a God-given objective phenomena for resolution of societal conflict, as if law was itself value neutral. A time has come when law schools like Kisii University must relook their curricula to ask, to what extent are we engaged in an interdisciplinary and multidisciplinary study of law? To what extent is the curriculum of a law school like Kisii University engaged with subjects such as law and economics, law and politics, law and society, so that the future judges that we are generating from Kisii University are men and women who are adequately experienced, whose knowledge is knowledge that comprises of experience on law and the economy, law and politics, law and society itself, as opposed to just law as rules, as an end in themselves. That is critical. The other broader question that must bother us is this. In its origins, law was never meant to be a first degree. If you look at the origins of legal philosophy in the olden Roman times, where what you now call jurisprudence was called jurisprudentia, and what you now call jurists were called jurisconsults, law was studied by men largely, and women to a lesser extent, who had experience in other philosophies and sciences. So that one had to go to an institution of higher learning and pursue a program in mathematics, in philosophy, in literature, in economics. Once you graduate in each of those disciplines, you now become eligible to study law. The understanding at that time was that a study in history exposes you to an experience of humanity. An study of mathematics exposes you to an experience of logic. A study of literature exposes you to an experience of society. A study of history exposes you to an experience of society. That once you already have that experience, and you now sit in a university law class and you are studying law as rules, you are better placed to look at the rules you are studying against the background of the knowledge you have acquired in your earlier programs, and you are therefore bound to graduate as a lawyer who can delicately balance law and politics, law and society, law and philosophy, among other phenomena, in a neater manner than we do as lawyers who studied law as rules, as ends in themselves. So that's another recommendation that I'll make to you. I was reflecting on the teachings of law in the Philippines. There's a famous, those of you who study environmental law have studied a famous case from the Philippines called Oposa versus Factoran. And if you study the philosophy that the judges espoused in Oposa versus Factoran, in summary, was a philosophy of intergenerational justice and intergenerational equity, where some young children filed a case in court through their parents. So the parents didn't file the case in their own right. The parents filed the case as representatives of their young children. These young children were seeking to assert their own rights and the rights of children unborn to a clean and healthy environment in the future. And how they were doing this was by challenging a decision of the minister in charge of forests to give timber lumbering licenses, as we do in this country oftentimes. And the argument was simple, that if you go to these deep indigenous forests, like the Congo Basin, these forests have been there since the beginning of things. And existing generations have benefited from the ecological benefits of these forests up to now. Since they are about to die, they are giving licenses to people to cut them down and sell timber, and the persons most affected are generations unborn. And therefore, the court has a duty to intervene and affirm the rights of generations unborn. That was a very unique case at that point in time, because the way we know this thing called standing, locus standi, those of us who do litigation, perceive that locus standi is a right of actual legal persons. When you talk about generations unborn, controversial philosophical questions arise. Who are those? Who knows them? Where do they get standing from? But the courts asserted that principle of intergenerational equity and intergenerational justice and affirmed the rights of generations unborn to a clean and healthy environment, and quashed the decision of Factoran Jr., the then minister, who had given those licenses. I was reflecting on that case and asking, how did these judges engage with the politics of that case? Now, make no mistake, Oposa whose son is called Oposa Jr. So Oposa himself was actually a lawyer by training. And he knew he could file this case in his own name. But, you know, when you file cases in court, and I do that all the time, particularly public interest cases, you must be strategic. That's why we sometimes call public interest litigation strategic impact litigation. You must be strategic, and you must ask. Judges may determine this matter using the law. But what if I emotionalize this case? Now you are politicizing the case. I emotionalize this case by filing it in the name of a 3-year-old. So that the person whose case the judge is dismissing is a 3-year-old. It is much easier for a judge to dismiss a case in Ongoya's name than for a judge to dismiss an environmental claim by a 3-year-old child. So he opted strategically to file this case in the name of the 3-year-old. I then follow to ask, how have Philippines law schools, particularly the National University of the Philippines at Manila, done to create lawyers who are this sensitive to these political strategies? I learned that university has an interesting thing which you may take as a law school and see whether you can pioneer in that area. When you join the National University of the Philippines in Manila, you don't start by getting lectures in law. You don't start by learning definitions of the Constitution or constitutional law or definitions of contract or tort. Name them. When you join the National University of Manila, the first 2 weeks, you go and live in a nearby slum by the slum dwellers. The university gives them something small to facilitate your upkeep there. So you live with them. You go to the markets with them, you go to the river to fetch water with them, you take water, you take showers in their shanty bathrooms with them. For 2 weeks. When your parents drop you at the university, they look at the university hostels and think that's where you're going to live. But the university has other news for you. That evening, you are spiraled into the nearby slum to live with the families there. You eat their food, you go to the market with them, you go to the river with them. 2 weeks later, you come back to the university a human being. You now begin understanding that the law you are studying here is law for justice, not law as rules, as ends in themselves. And because of that, the University of the Philippines in Manila has generated human-centered lawyers. Lawyers with a heart for humanity. Lawyers who understand that the law that they study in the university is as useless as it comes unless it can serve that slum dweller in whose shanty they lived for 2 weeks before they came to the university. I have argued elsewhere that as we look at our training models, that to me is a model we must think through, because as members of the university community, we are a privileged lot. Just by living in this university, we have power whose monthly bills we don't even know. Neither the dean nor his student or his lecturers know how much monthly bills they have for this university. Somebody somewhere pays it. That's a privilege. Unless you go out there and live in the slum and see how somebody cannot afford a token of 5 shillings, you may not be very sensitive to this power. You may actually abuse it. But if you came back to the university with that sensitivity, you'll use water more responsibly, you'll use this power more responsibly, you'll appreciate the greenery here, you'll appreciate the food you get in your hostels, and you'll be generally a more responsible citizen who understands that the law that you study in law school and the law that you'll practice out there is law that is supposed to satisfy broader social aims. So what am I saying in closing? I am saying this as a university community that is generating the next generation legal practitioners, the next generation judges, the next generation attorney generals and state counsel in the office of the attorney general, as the next generation prosecutors in the office of the director of public prosecutions. I want to leave you with a saying that the price to pay for justice, the price to pay for good governance, the price to pay for an organized and well-ordered society is not law as rules, as an end in themselves. The price to pay for all these phenomena is actually a non-legal phenomena called eternal vigilance. And therefore the question you must ask yourself is, how do you build the art, the skill, and the science of eternal vigilance? I suppose no answer to that question. I leave it to your individual senses of judgment, and thank you so much for your audience.
Can we clap once again for our speaker? Thank you. Yes. Yeah, we are going to get to the next session, which will be plenary, that we expect questions and responses from our chief guest. But among the things that have attracted my attention most is the principle of inter and intergenerational equity, which requires and it creates obligations among most of you who have more years to live than us, that can you be more vigilant in fighting for your rights, whether they are environmental rights, whether they are political rights, but rights in general, because do not allow the old generations to waste resources so that when you get there, you find a more hostile environment. In other words, if you need to have better life in future, the chief guest has encouraged us to have internal vigilance, meaning that let's keep our eyes open, let's keep our brains sharp, and let's speak out against injustices. So can we clap? I'm going to ask George to take over this session of plenary so that we can get the questions, probably maybe 3-3, maybe 4-4, according to the preference of the chief guest. And George Adipo is one of our lecturers at the law school. And please, George, can you come and take over? Thank you. Can we clap for George?
Thank you very much. To our chief guest, once again, we welcome you to Kisii University and in particular to the School of Law. Good evening, students. I know the group from the School of Law know me fairly well. The others maybe not quite so, but Adipo is my name. Members of the Law Society, we appreciate your indulgence to be with us today because clearly all these students need to know, as the chief guest has told us, that law is not an end in itself. In fact, one key point that Mr. Ongoya has made, which you all need to carry away, particularly the law students, or rather the students of law, is that you are not learning the law in a vacuum. In particular, the students of the philosophy of law, Ms. Ongoya, I teach jurisprudence around here, and I've reminded them many a times that philosophy of law is central, particularly to lawyers, because you need to know why the law, who is the law for, where does it come from, why must we obey it? These are questions that nobody provides you with a specific answer, but as a student of law, you need to reflect on them. So I'm happy when Mr. Ongoya was propounding those questions, particularly for reflection. However, we as students, all of us, I always remind students of law that the world does not owe you anything. So that when you come from here, you expect that, you know, you just graduate and you'll be rich. You know, you get out and the world owes you. You start earning lots of money, etc. No, the practical thing that happens on the ground is very different. You struggle every day. Okay. But most importantly, philosophy, law, and politics rather belong to the same WhatsApp group. You've been told here, and now you know. If you didn't, so you know. So much for that. We now come to the question and answer session. I'm sure you have questions that are bothering your mind, and our chief guest is here ready to answer those questions that are in your mind. Hopefully, we hope they are going to, you are going to make them brief, short, and very clear, so that you don't yodel around, so that the actual question does not come out clearly for purposes of brevity. So once again, we invite you now to start shooting your questions so that we see how the chief guest will respond. But bear with me one moment. Ms. Ongoya, I would like to bring to your attention that among the students here are mooties, people who are participating in local moot court competitions, international moot court competitions, and I'm aware, having read your history, that you are one of the strongest mooties when you are at the University of Nairobi. I mentioned before, and I thought you were going to get time to emphasize to them that being a mooter is key to honing your skills. They sweat, they fret, some of them collapse here when time comes to confront your own colleagues. What about when you confront an international audience? So perhaps you may want to pose a question or two for those active mooters when you get time. So much for that. Please, could we go straight on? Was your hand up? Right, are we going to use another microphone, please? I thought I saw another microphone up there. Okay. All right then, I'm advised that you are going to have this one and then you bring over to me some other one. So please. First person? Right. Maybe give them a number. Oh, all right. Okay. Yeah, the dean advises that I give you numbers. How many? Yeah. How many do you have? Can do one at a time. No, there's another microphone. Oh, one at a time. Yeah, we don't close one at a time. All right then. The Mr. Ongoya says you'll shoot the questions and he responds contemporaneously. So here we go.
Sorry, Mr. George, In view of that direction, the first question came from you, because I had to share also my thoughts and my experience with the method of learning through moot court. So I'll start with that one, so that we don't breach the rule of one at a time. The methods of teaching and learning in law schools continue to change. And they are changing even more fundamentally in today's time. And as the crop of learners that we call CBC learners get to the university, we will have to fundamentally alter the methods of teaching law in the universities. And this is something we are thinking across in many law schools. I trust even at Kisii University, it's a challenge you are trying to anticipate and grapple with in advance. And the existing tool is, how do we get learners to be co-creators of knowledge in the learning environment? So we then employ a method of teaching where people learn by doing. It's called clinical teaching and clinical learning. One of the most efficacious methods of clinical teaching and learning in law schools is by use of the moot court. And I think, Mr. George, I must point out that I was privileged to participate in moot courts when they were not a very old phenomenon in the country, and when we were learning a lot as on the ropes as we participated. Courtesy of that, are there people here who have participated in the ICRC International Humanitarian Law Moot Court competition? Anyone by show of hand? Yes, there's one there. I am happy to report that when that moot court started approximately 24 years ago, I participated in the inaugural edition of that moot court. And I was also privileged to bring home the title 24 years ago, when we were just starting. 23 years ago, I was designated by my university law school to take the subsequent team to that event, and we also brought home the title. Don't wonder why we were bringing home titles all the time. By that time, the country had only 2 university law schools. The whole country had only the University of Nairobi and Moi University. And the total number of learners taking law in the whole country at that time was 167, in the whole country. Only 167 Kenyans were studying law locally, unless you opted to go out of the country. And therefore, it was not that hard to bring home the trophy. The teams among which we are competing were fewer, and the number of participants were fewer, and the interested participants were even fewer at that point in time. I was privileged to also participate in the All Africa Human Rights Moot Court competition, and I was privileged to participate in the Philip C. Jessup International Law Moot Court competition. I'm not talking about events of yesteryears. I'm talking about events that are more than 2 decades old. And therefore I may be sharing with you knowledge that is past its sell-by date. So take it with a pinch of salt. But the lessons I gathered at that point in time was that the relationship between the abstract knowledge we acquired in class through the lectures of our lecturers and the practical reality of attempting to apply that knowledge in drafting memorials and making oral arguments before moot court judges enabled us to build a finer, more sound understanding of the law. I think that is something that it holds true today as it held 2 decades ago. That if you are in a university law school and this university gives you an opportunity to participate in internal moot courts or regional moot courts or international moot courts, please use it. I have a more immediate benefit incentive for doing that. I keep telling my contemporaries that unlike many of them who paid school fees in the university and only indirectly used it through the books in the library, I used all my school fees and other students' school fees. Because to go to the Philip C. Jessup International Law Moot Court competition, the University of Nairobi spent a total of 1.5 million shillings on me at that time, against the 16,000 shillings I was paying per year. So suddenly I used my fees directly. And therefore, if you have no other incentive for which to do it, at least do it to recoup your fees and go away with it. I hope that will incentivize a lot more of you to try that out. But the collateral benefit that you get, which I think George wanted us to bring out, is there is a lot of learning of law in those spaces. That's number one. There is a lot of cross-cultural learning. Just the whole experience of meeting other people from other law schools, from other countries, who have different lecturers. I know many lecturers carry different forms of lunacies. So you have your own lunacies here from your lecturers, but you have other students from other environments with their own lecturers and their lunacies. And therefore, you become better lunatics in the acquisition of knowledge. I keep telling my students there's an element of lunacy in acquisition of knowledge. And the more lunatic you are, perhaps the more the knowledge you acquire in the process. So I just want to emphasize the fact that moot court participation is perhaps the most clinical and efficient methods of learning by doing among learners. And the more you engage in it, the better. Let me take the next question. If you could just give me your name and your question.
Thank you very much. My name is Samuel Barasa. Yeah, first of all, I would like to associate myself with you because we are also mooters in the school and we participate in competitive moots. For example, this year we're going to represent our school in the ICC moot court competition. Yeah, and Mr. George is our coach. Okay, now straight to the question. Mr. George once referred us in his constitutional classes to a debate in the University of Nairobi between Dr. Willie Mutunga and Attorney Justice Emeritus Githu Muigai. And the topic was, does the Constitution have a theory of its own interpretation? And there are questions of judicial activism, which you've just brought to play, and we have discussed judicial activism here. Now, my question is, are you pro-judicial activism, or you would prefer judicial restraint? Now, my last question is pursuant to that judgment on LGBTI that we really are still deliberating on. Paragraph 16 of that judgment, if I got it clearly, the interpretation that the judges were giving us is that yes, we can have associations formed by LGBTI people, but then there is a penal sanction still to LGBTI practices. And I was likening that to a situation where we're saying that yes, we can form associations for robbers, but then at the same time, robbery is a crime. So I'm wondering, do you agree with that judgment, or do you dismiss that as just politics or judicial activism? Thank you very much.
Thank you so much.
Lovely question.
Thank you. Let me deal with that. First of all, I think congratulations for your engagement in extracurricular activities in Baraza. I noticed that you've mentioned here you are participating in the ICC moot. I also take judicial notice of the fact that you are the one who invited me here as the congressman for the school. That means that your life on campus is balanced life. It's life within and life without books. And one thing I encourage the university community is that you must build what I call a campus experience. That when you leave this campus and 30 years later you look back to your days at Kisii, what is it that will make you look back with nostalgia that we had a campus experience? I don't know about each one of you individually, but I would encourage you to do at least what has manifested itself to be what Mr. Baraza is alluding to. And maybe before I forget, now that I'm there, Mr. Baraza, and to the rest of you who are at Kisii University, many years ago, I think the year 2016, I'm told, was when the first graduating class of law graduated from Kisii University. And that class went to the Kenya School of Law in Nairobi, and they sat for their advocates training program exams. And the Council for Legal Education has a desegregation formula where when the results come out, they desegregate the results of the students as per the university of origin. And Kisii University had the highest pass rate at the Kenya School of Law. And I was meeting the then dean of the Strathmore University Law School, and I was telling him that, you know, the name Strathmore University sounded very big at the time. I said, why don't you go to Kisii and ask the dean there what they are doing differently so that your performance is commensurate to the big name that you carry. Reason being that Kisii University has sustained that performance. In the CLE exam results that came out on 19th of December last year, the top student at the Kenya School of Law was from Kisii University as well. It was a lady. as you sit in this room, I therefore want you to sit here with the full confidence that you are in a top law school in this country, at least by all objective indicators. I'm not saying this to please you, because this data I am giving you, I'm not creating it. This is data by a completely different body that is authorized by the Republic of Kenya to be the regulator of legal education and to be the central examiner of all law students in this country who want to practice law. So it's a fairly objective data that gives me that. And if you are among those who are not working very hard, you must ask yourself, what are you doing to the good name of Kisii University? I know the dean here will tell you that the good students are inside this hall. The good learners are inside this hall, but all of you know the bad ones who are farthest from this hall today. Anytime you organize activities like this ones, the bad ones run farthest from that area. So those ones are very interesting people. They are the ones who keep the dean busiest. They have missing marks, so all the time they are there missing marks, all through complaining about which teacher has not done what. They don't attend classes, they have not met the threshold for sitting exams, so they are pleading for the dean to take onto account the day their mother was sick. The day their mother was sick. So coincidentally also God works in mysterious ways. Sicknesses also just follow those ones. So they also have a way of telling you, see, my mother was sick on this day, then I was sick, then my great-grand-aunt was sick on this day. So that's why I didn't meet the threshold for sitting for exams. But for those of you who are in here, you are carrying with you a rich legacy of a rich law school that has been confirmed elsewhere by objective decision makers. I have been a consumer of both Professor Githu Muigai's philosophy and Willie Mutunga's philosophy on two fronts. One, Professor Githu Muigai was my pupil master, and therefore I have engaged with him very closely and I understand his philosophy of law. Professor Willie Munyoki Mutunga works with me at Kabarak University, and therefore I've had the privilege of working very closely with him. And therefore, the two great men of this country who have served in the most prestigious offices of Chief Justice and Attorney General are men I've had the privilege of working closely with. That's number one. Number two, Professor Githu Muigai was Willie Mutunga's student at the university. And Professor Githu Muigai was a pupil to Willie Mutunga. And therefore, their paths, I must concede that the intellectual relationship is fairly incestuous, if you may, as a result. So their philosophy does not always tally. William Munyoki Mutunga is from the Dar es Salaam old school that was bred by people like Isa Shivji, people who are dyed in the wool, socialists at heart, and he has kept that spirit of socialism. Professor Githu Muigai, on the other hand, took his studies in America and came back with a fairly capitalistic spirit, and you can read it in their philosophy. Given a chance, Professor Githu Muigai would be significantly textualist in his reading of the law. Willie Mutunga would be more inclined towards the spirit of the Constitution in his reading of the law. That is just from my own observation of the two great men of this country as I interact with them. They both mean well. When you meet both of them at a personal level, they both want to see a well-governed country. When you talk to them, they don't like the disorder that we see around here. They wish we ran the affairs of our country, observing the twin principles of constitutionalism and the rule of law. I am a function of moderation in all that anyone does. I'm a firm believer that anything that we do, anything that we partake in real life, I'm a very moderate human being. I am not an extremist at anything. And therefore, I have not personally taken the view that one must choose on an either or, an all or nothing scenario between activism on the other hand and restraint on the other hand. I've taken the view that both philosophies can be consumed with moderation. I have always taken the view myself that the starting point to interpreting any document, forget about the Constitution, is by reading the document itself. You can't claim to be interpreting a document that you have not read. And therefore, I believe every interpreter of any document, including the Constitution, must first and foremost be textualist. Read the text first. Then ask, what are the social aims that we desire to see as a country? then ask finally, what meaning can we give to this text that will drive the vision of that social aim? That's my understanding of a purposive reading of the Constitution. A reading of the text with a purpose to achieving predefined social aims. So that if we want a more democratic country, we must ask, what meaning do we give to Article 138 to guarantee gravitation towards democracy, as it were? So that is my take. And to the extent that the text itself can achieve that social aim, then I'll be a subscriber to a limit of restraint. To the extent that the text itself requires some extra reading in to be able to achieve that social aim, then I'll gravitate towards the activism necessary to achieve that end. So apart from the fact that I am a firm believer in moderation in anything in life, forget about the law, then I do not personally believe that there is an all or nothing choice between judicial activism and judicial restraint. To the question whether I agree with the LGBTI decision of the Supreme Court, I trust that the law students here know that there is a pending case at the Court of Appeal between Eric Gitari and the NGOs board on whether to declare the provisions of the penal code that prohibit having carnal knowledge against the order of nature unconstitutional. And I believed myself that the Supreme Court put the cart before the horse, because to my mind, the question of nullification of the section of penal code ought to have had in advance of the question of legitimation of the association. Otherwise, legitimating the association when there is a decision of the High Court sustaining the penal code provision led to interpretations in the nature of the one you have alluded to, whether it is also possible then to allow robbers to register the Kenya National Association of Robbers or the Kenya National Association of Murderers. It must be logical, and I think that is where the Supreme Court fell into error or philosophy of law by failing to look at the logical consequences of its decisions at that point in time. The next question.
I guess this should go to a non-law student in and a lady, I believe. A lady non-law student?
There's one there.
Somebody, all right. No, that's a law student. Okay. We know that. A lady in particular. A lady? Non-law student? Right. Over there. Oh, didn't I see a lady's hand? Faith, you are a law student. We want, okay then, if this no non-law, a lady student, then a man? Yes. You want to pass that.
Okay, thank you. I'm Lennox Ochengo Odhiambo. I'm a student of education, taking my education course, special needs education. And I have a question. My question is concerned according to the sentiment that you made earlier about whether the law is a product of politics or politics is the product of law. And my logic tells me that law is a product of politics. And in a case where the judge fails to obey the collegiality law, and that may occur due to maybe interest, since we say that maybe at a point judges also they make their judgment according to political side and some influence. So the judge fails to obey the law of collegiality. What action or jurisdiction action can be taken to this judge to ensure that he is taken accountable? Thank you.
Thank you. Thank you so much, Lennox, and thank you for that question. There was an earlier question before you asked. The earlier question was whether there was any non-law lady student wishing to address us, and none carried up their hands. And one day I was arguing a case before a 3-judge bench. That was Justice Mwera, Justice Mwilu, and Justice, I'll give you the name of the 3rd judge shortly. And this was the famous case of the Federation of Women Lawyers, Kenya versus the Attorney General, where we were challenging the composition of the Supreme Court. And the reason why we were challenging the composition of the Supreme Court was that we said that the judges of the Supreme Court, their numbers on gender grounds did not meet the 2/3, 1/3 gender parameters. And after I had made my arguments, because I was privileged again to be appointed the lead counsel for FIDA in that matter, Justice Warsame, that was the 3rd judge, asked me why I, a man, was arguing that case if I strongly believed in the gender question. And I told them that I had designated myself an honorary woman, for purposes of arguing that case. And coincidentally, the case coincided with the time when my mother had visited me in Nairobi from the village. And because I didn't have somebody to keep her busy, she had accompanied me to court. So I reminded the judge that I was also the son of a woman who is sitting there, and my mother had the privilege of having to greet the judges in the course of a public interest litigation. That is not the only matter. You may notice that I was involved. Many of you will remember the time when Chief Justice Maraga ordered the president to dissolve parliament, isn't it? I was involved in litigation of all those cases that led to the Chief Justice ordering the dissolution of parliament. Because I'm a firm believer in women being present at the decision-making table, not just for the sake of presence, for the sake of having their voice primarily heard, their voice heard from them. And therefore, unlike George here, who asks a woman to carry up the hand, in the rare occasions when I'm chosen to moderate cases, I don't do that. I'm a firm believer in the capacity of women in themselves to raise up their hand and participate in proceedings. And I am also a firm believer in the fact that it is not right. It is not right for us to precipitate a scenario, and here I'm addressing women, where people must plead with us to participate. When you cause people to plead with you to participate, you illegitimize the cause that suggests that we are up to the task. Having said that, let me address Lennox Ocheng Odhiambo's question. Lennox, thank you so much for attending this seminar as an education student, because this is a starting point towards ensuring that our law students here are engaged in interdisciplinary and multidisciplinary conversations. They are able to listen to the voice of non-lawyers and ask, how do non-lawyers perceive the phenomenon of law, so that they moderate their own perception of law from the perception of law of non-lawyers. I, like you, agree that law is an emanation of society, and society is what we call the polity from the old Greek times. The word politics comes from the word polity, and polity just refers to all of us as a society. We are the polity, and therefore law is a product of us. So law, to that extent, is a product of politics. But even the law-making process itself, look at the law-making institutions. In this country, if you look at Article 94 of the Constitution, the institution to which we have conferred the power to make law is Parliament, a political institution itself. What happens in Parliament is pure politics. How we constitute Parliament is a political process, isn't it? So to that extent, again, I agree with you that you are right, that law is a product of politics. But scholars who have engaged with this subject have known just the extent to which politics unregulated can take a tangent of their own, and we never know where they will lead us to. If you look at the way politics plays out and the way politicians behave, sometimes leaving ourselves to their mercies can be tragedy of monumental proportions. So as a consequence, we have created three distinct organs of this three-legged stool called the state. The first organ is, of course, the legislative institutions that operates on politics, with politics. Its day in there, its life is politics, its blood is politics. Then we've created another legislative institution that is called the executive, whose operating medium is policy. So if you look at the way executive organs work generally, they try to apply, implement, enforce policy, administrative policy, and so forth. Then now we come to the judicial, which, although we know it plays politics, it has hidden its politics in the name of principle. And we therefore must have an organ that we keep on calling upon to remain the principled institution, the principled organ of the state. And what we assess judges along is whether they remain at least within acceptable parameters. Not pure parameters, because from my previous presentation, you know I believe it's not possible to get judges into pure principle, but at least within acceptable, broadly defined, acceptable parameters of principle. And a judge who navigates outside the broadly defined parameters of principle then becomes an ill-behaved judge. Judges enjoy security of tenure, as you have all learned, but where I teach law, I keep reminding my learners, it is not absolute security of tenure. It's security of good behavior tenure. And therefore, when judges become of bad behavior, we have methods of removing them from office. And I'm sure those of you who even follow news know that there are judges we have removed from office because of bad behavior. So for example, whereas judges are expected to interpret the law and apply principle, if we discover that the judge in question received a bribe, the way the average citizen receives a bribe to vote one way or the other, the judge received a bribe to make a determination one or the other, then we remove such judge. We don't say bribery is a reality of our politics and therefore we understand the judge. We remove them from office because we expect that even where they are playing politics, they remain within some broadly acceptable parameters of principle. Next question.
Right, behind there, the lady looking back behind, yes, yourself.
Okay, thank you so much. I'm Marogo Veronica from, I'm a media student, 3.2. So my question is on the freedom of expression. To what extent should we go in the line of expressing ourselves, bearing in mind the political times that we are in? Like, if you go through the social media right now, you'll see some people trying to demonstrate some cartoons or something. So to what extent should we go? Then again, are there laws that limit the freedom of expression?
Yes. Thank you. Thank you so much, Veronica. Veronica, there's an old and famous American Chief Justice called Wendell Holmes. Chief Justice Wendell Holmes was reflecting on the scope of protected speech and unprotected speech. So protected speech is what you call freedom of expression. It's one that is protected by freedom of expression, and unprotected speech is the one that is not protected by the freedom of expression. And I like using his words to answer a question like yours. He said that yes, we know there is free speech, but free speech does not entitle one to enter a packed discotheque and shout, "Fire!" Then when asked, why did you do that? He says, free speech. You and I know what will happen to revelers. No, revelers love life. That's why they are there in the first place, isn't it? Revelers love life. I mean, they live life. They like life. If you shout fire in a packed discotheque, there will be pandemonium. There will be a stampede. Life limb is likely to be lost, isn't it? And therefore, if free speech comprises loss of limb or loss of life, then that becomes unprotected speech, according to Wendell Holmes. However, what advanced democracies have taught us, and we continue to learn from them whether we like it or not, is that we must enhance our capacity for tolerance. In fact, free speech from a legal constitutional philosophy point of view is not meant to protect ideas that we agree with. Because if we agree with ideas in the first place, we are not going to be offended. So the idea of free speech becomes unnecessary if people speak only those ideas that we agree with. Free speech comes in to protect people who propound ideas that we don't agree with. That's where free speech comes into operation. Otherwise, if I keep telling you, you're a good person, you are making progress, why would I need free speech to say those things? What danger do I stand for saying those things? Nothing. Free speech becomes necessary when I begin speaking ideas that are critical of you, because then you are likely to hit back, and then therefore I need protection of free speech for me to be able to do that. But if you look at our Constitution and you look at Articles 25 and 24, they play important roles. Number one, Article 25 of the Constitution sets out rights that are non-derogable, rights from which no limitation is permissible under whatever circumstances. So no one can limit them. Freedom of expression is not among those rights listed in Article 25, meaning free speech is derogable, it can be limited. Article 24 gives us the criteria for limiting rights. So you look at it before it prescribes that there must be a law limiting those rights. In fact, the first law to limit free speech is the article conferring free speech itself. Under our Constitution, freedom of expression is provided for under Article 33 of the Constitution. If you read that article, it has an inbuilt limitation. It says it does not expand to speech that is, for example, propaganda for war. So if you begin advancing propaganda for war, then that is not protected speech. Speech that advances hatred on any of the grounds of discrimination that are set out in Article 27. So if you look at speech that advocates for ethnic hatred, for gender hatred, for hatred of persons with disabilities, then that is not protected free speech. So in answer to your second question, free speech is not unlimited. It is limited to the extent that I've alluded to in my substantive response to your question. Next question.
Just before you go to the next question, I hope the listeners understand that even text messages is part of speech, right? So next, over there. Yes, yes.
Thanks for the opportunity. I'm Biti Zauma. So this is my question. I have a contentious issue that always go around my mind, that the topic of today was politics and law. And let us consider the fact that the part of the executive and the legislature, we found that our MPs, once they are there, they tend to express their own views, but not the views of the people they represent there. And also my point of concern is the point of the Supreme Court. The Supreme Court, we find that there is, at one point, the separation of power is not clearly drawn, because the executive tend to have more power, and that lies on the fundings. Yes, so we find that there is some pressure that our MPs, the lawmakers, they have once they are in that house, and also to our our judges in the judiciary part, we find that there is also some pressure there that they get from the executive side that always make them to make judgments that are not maybe correct. Yeah, that's my question. So maybe you can shed light on that. Thank you.
Thank you, Ms. Auma. You noticed that when I walked in and my topic read politics and the law, many of you may have thought that I was going to limit my conversation to politics as in election campaigns or campaigns for public office and so forth, and I deliberately abstained from that path because I call that politics with a small p. Politics with capital P is the business of all of us, and we engage in that business every day because each one of us, whether we like it or not, have some interests, whether as a community, whether as gender, whether as religion, whether as youth, whether as students, whether that's politics. So that when the government is saying we are going to start a new funding model for university students, that is politics, and you can't run away from it because it will affect you. When Parliament is saying we are beginning a new medical cover scheme, that is politics. You can't run away from it because it will affect you. And therefore, I wanted us to have that broader understanding of politics, which I call politics with a capital P. It is true that some of the members of the executive, some of the members of the legislature, and some of our judges are not true to their calling, and they are not true to their oath of office. And that is frustrating for you as a citizen. That's frustrating for me as a citizen. But that is human nature. Human beings are inherently selfish. It's the nature of human beings to try and Waswahili walisema kila mwamba ngoma uvuta kwa upande wake, si ndio? It's the nature of human beings, which is why I drew your attention to your inherent obligation as a citizen in your own right to be eternally vigilant. I knew why I was saying that. If you depend on the altruism, the good-naturedness of your MCA, your member of parliament, your women rep, your governor, your president for anything, you are doomed. You elect them, you give them an oath of office, and you remain eternally vigilant. Let me give you an example. Fortunately for we as a country, we have been alive long enough to know just how much we can benefit from eternal vigilance. Number one, last year on 25th of June, the president of this country, parliament in this country, voted that tupende, tusipende, tutake, tusitake, tutakiwe, tusitakiwe, we were going to be saddled with a finance bill that they had passed. They recalled it. Didn't they recall it? Courtesy of whose efforts? Ordinary citizens' efforts. Some citizens whose names we had never even heard of before the Gen Z uprising. And that teaches you that there is a place for eternal vigilance, that let us not despair, that we can get our country to operate properly if we are eternally vigilant and we call out people to account. Not long ago, when the president was somewhere talking about how this social health insurance fund is working, citizens from hospitals, sick people, went to the minister's boardroom and said, no, you are lying to the public. These are people who none of us had known before that episode. These are citizens asserting their voice. And when the state tried to arrest them and take them to court, they didn't even take them to court. They had to withdraw because the consequences of taking those people to court were too drastic to imagine. I can assure you, as a member of the Law Society of Kenya, that the Law Society of Kenya was going to mobilize lawyers of unprecedented proportions to attend in court and defend those people. That is the eternal vigilance that I am talking about. And you know, when we read our constitution today, there are a significant number of people in this room who hold passports. you went to Kisumu and applied for a passport, and after 21 days, you went and collected it. If you ask a man called Gibson Kamau Kuria or a man called Paul Kibugi Mwite, they will tell you they lived in this country when getting a passport was a privilege. Now, a passport is a right. Men and women who know and knows apply for passports and get them, courtesy of this kind of social movements and social struggles. So, to Mr. Uma, yes, I know that just like you, when I wake up in the morning and read news of a very overpowered parliament, a very self-centered parliament, a very selfish parliament, just like you, I feel like despairing. But then I ask myself, what society will I leave behind in the hands of my children and their children if I give up? That alone gives me the energy to wake up and fight a little more with the tools at my hand. And the tools in our hands are many. As a litigation lawyer, I often go to court and challenge governmental actions. Sometimes courts agree with me and they strike down acts of parliament. As a social media user, you can put a responsible post calling your MCA, your governor, your MP to order. And by the way, they read those things. We now know that politicians fear people who call them out. To the extent that you disagree with what they are doing, make it a point to call them out. And as university students, as the university community, never forget the fact that you have a special calling to be the conscience of society, because you are more exposed, you are privileged, you are more knowledgeable, and the knowledge you hold is not your private good. It is a resource that you hold in trust for the rest of society. If we do that, we shall not necessarily get a perfect society, but we shall get a functional society, one that by and large can keep us going against multiple odds. Next question.
Brilliant. Two more questions. One from this side, one from the other side, perhaps. Over here in a colored shirt, please.
Thank you. I'm Pius, a political scientist. My question actually is, for the case of politicians who have actually pursued also law, can there be a scenario whereby they can deviate from the reality of law and focus on in politics? For example, in the case of one of the cases that we had recently in Kenya. Thank you.
Our chief guest is going to take the two questions together. So the last question from this side, yes.
I'm Kenneth Mbogo, a student of laws. First is to compliment you and confess that I admire your skills in cross-examination. Secondly, let me dive into the question. My question is whether there is a possibility of the judiciary to maintain its independence in politically charged cases and maintain the principles of the law. Thank you.
Thank you for the two questions. Pius, you mentioned something that you called the recent case. I'm not a mind reader, and therefore I will not presume that I know what the recent case is. But I will answer your question whether it is possible for lawyers turned politicians or politicians turned lawyers to deviate from the law. Let us face it, we began by building consensus that law is an emanation of society. Law is a product of politics. And those people we call politicians, just like you and me, are a product of society. And I began by mentioning something else, that human beings have certain innate tendencies, certain inherent characteristics. One of the inherent characteristics of human beings is that they are selfish. They are selfish. That's why human beings steal. That's why you close your door at night, because a selfish human being will want his own property and your property as well. And a lot of things around us teach us that human beings are selfish. Because of that, it is highly likely that yes, human beings, politicians, can deviate from their training and calling as lawyers to engage in self-interest. And we witness that every day of our lives. And I'm not saying this is just limited to politicians. I'm saying this is an attribute present in all human beings by virtue of their human nature. That is why institutions of checks and balances exist. Let me give you an example. Your teachers here have a duty to come to class timeously and teach as and when they are required. But we have set up an institution of dean to ensure that that is monitored, because they could use the time they are supposed to be teaching you for private gain. That is selfishness, isn't it? So we keep on setting institutions of checks and balances to ensure that all human beings comply with expectations, because we know that being human beings, by virtue of their innate tendencies of selfishness, they have capacity to deviate. And the most effective institution of check is we the people, because number one, the Constitution at Article 1 bestows upon us ultimate sovereignty, and we also know that we can name and shame them and there's nothing they can do to us. We also know we can vote them out after 5 years and there's nothing they can do about it, and so forth. And I keep saying that obligation is even more poignant when we are dealing with you and me, people who have had the privilege of learning up to higher levels, because then we are a conscience of society. We can't judge ourselves at the same level as our other siblings and relatives who have not had the privilege of learning up to this level. Kenneth, thank you so much for your compliments, and maybe since I'm answering you, let me mention something about the art of cross-examination. The art of cross-examination is an art of truth-seeking, an endeavor to seek truths from fellow human beings. And when you cross-examine, you must always ask yourself this question: what type of witness am I dealing with? There are very many types of witnesses, very many. There is an old book by some Indian authors called The Art of Cross-Examination. It's red-covered in book. It's a red-covered book. The Art of Cross-Examination. Aya and Aya. The Art of Cross-Examination. If you read that book, you will understand how we assess, size up, and deal with individual witnesses. So you must begin by categorizing your witness. Either is a lying witness. I dealt with one. I guess many of you came to know me because of dealing with a lying witness. Once you know that this witness is a lying witness, there are tools of dealing with a lying witness. In fact, from a practice art point of view, a lying witness is the easiest one to deal with because of, again, human psychology. It is impossible to tie all the loose ends of a lie. It's not possible. Yes, that's just the way the human mind is. It's not humanly possible to tie all the loose ends of a lie. And as a consequence, you always get caught. If you begin lying and you appear before somebody who is properly schooled on how to deal with lying witnesses, you will 100% you'll get caught. And you'll get so caught so embarrassingly that even the worst fool in the room will know that you have been caught. So the fact that you have been caught will not depend on the judgment of the speaker or the judge. No, the average market woman will know that huyu ameshikamatwa leo. There are truthful witnesses, there are expert witnesses, there are evasive witnesses, there are all categories of witnesses, and you need just to ask which witness am I dealing with and approach him appropriately. You'll be able to deal with that. For those of you who aspire to be litigation lawyers in future, I hope that we shall meet in the real world to teach each other the art of cross-examination. To your question, is there a possibility of the judiciary retaining its independence in a politically charged environment. Now let me tell you the reality of life. There is a scholar called Herschel. Herschel has done a book called Towards Judiciocracy. And he has done a lot of analysis on what befell judiciaries across many countries in politically sensitive societies. So he looked at many countries that came from the old USSR and countries that came from the old Yugoslavia and what happened to their judiciaries. There was a time, for example, in Malawi, when the president of Malawi, Ngwazi Hastings Kamuzu Banda, created a parallel judiciary. He left the judiciary in place, but created a parallel judiciary of village elders who could deal with all cases, including criminal cases. So you just leave those judges there with their, then you just deal with a parallel judiciary of village elders. So different regimes have fashioned different tools of dealing with independent judiciaries. There are countries like Bosnia where the lawmaking institution just made a law and abolished the Supreme Court. You know, nothing stops the president of this country from standing on top of his 4x4s and talking as eloquently as he does and convincing all of you to vote in a referendum to abolish the Supreme Court. Because once we vote at the referendum, we are the ultimate people. And the politics will have abolished the Supreme Court. Judges are sensitive to these things. Forget even about that. There is a body in Eastern and Southern Africa called SADC. No, SADC, isn't it? The Southern African Development Community, something like the SADC. SADC had a tribunal. The way we have the East African Court of Justice. SADC had a tribunal called the SADC Tribunal, which kept making decisions against those governments there. They just met as heads of state and abolished it. They just removed it there. So I'm telling you that even the most independent of courts are not immune from political gymnastics that can harm them. But there are individual judges who try their level best to remain independent against the odds, to continue asserting the majesty of the law and the Constitution against the odds. But I want to remind all of you that judges in and of themselves are inadequate to defend themselves from political pressure. It requires citizens of goodwill like you and me, and civil society groups like the Law Society of Kenya and other social actors to continue demanding that the judiciary must be left independent. The state has different tools of emasculating the independence of the judiciary. Remember, for example, the judiciary requires resources to function, and the judiciary does not have its own resources. The judiciary relies on the executive and the legislature to give it resources. So the independence may not be an attack on judges individually, but their money can just be reduced through parliament. How do you deal with that? You need men and women like you and me who are vigilant to look at those signs, and when the judiciary's budget is being taken away, to ask, why are you taking away that budget? That does not mean that we are doing that because the judiciary is perfect. No. You must also be on the lookout and look at elements of corruption, elements of compromise in the judiciary itself and call them out, because those are worse off rodents at the independence of the judiciary. Internal threats to independence are more lethal than external threats to independence. So this vigilance is not just vigilance, look at what the president or parliament or politician are doing in the judiciary. No, it's also look at what the judiciary itself is doing internally to ensure that what they are doing, by and large, remains within that parameter of principle that I talked about. Since those are the last questions, allow me to make my closing remarks, then I take my seat. First, you must regard yourselves as extremely privileged to have the kind of dean that you have here. Why? A lot of us in spaces like him are people who do our work routinely. I go to work at 8 in the morning, I leave at 5 in the evening, my salary is guaranteed. But you have a dean who goes beyond the call of duty to say, I can call a resource person to to come and primarily share his teachings, his learning, his experience with my students. Never take that opportunity for granted. Now, it's the nature of human beings to take for granted what they have. It's the nature of human beings to take for granted what they have and only begin appreciating it when they lose it. I want to beseech you to take full advantage of the opportunity that your dean is giving you so that you are able to benefit optimally from them. I've heard some of you say, for example, that Sir George here is training you in moot courts. Never take that for granted. He could just come here as a lecturer who looks at the timetable and say, no, I'm teaching constitutional law on Monday and jurisprudence on Friday. That's it. Drives here, teaches, and goes away. But they are here well past office hours, attending to you as their students. Not because they are the most remunerated men and women in the world, no. It's because they know that whatever little they make out of this place, they must make their presence worth being felt in terms of impacting your lives. Never take that for granted. And I've mentioned to you something before I want to repeat. Never take it for granted that you are in an institution that has been objectively assessed as a leading institution in training lawyers for practice in this country. If you do that, I suspect that even if you and me will not be alive 200 years to come, another generation will come here to an ultra-great institution, and the foundation that you and I laid by sitting in this hall and by giving this lecture would have contributed to the greatness of that institution years to come. God bless you, and keep going.
Now, we want to do it this way. We want to clap for 1 full minute non-stop. Can you start? Okay. Now sit for 1 minute. Thank you so much. I don't want to take the space of vote of thanks, Chair, my brother. I don't want to take the space of vote of thanks, but I want to mention 2 things. From the look of things, it's like some of you are unhappy with me. Why am I bringing this discussion to an end? True or false? True or false? Now, but there is good news that is coming. One, how many of you request that we invite Mr. Ongoya once more? Twice more? Yes. Then I'm going to follow up on what he has said, and it is always good to identify. The campus life is always good to identify with your classmates, isn't it? Now, he has mentioned one person and mentioned one institution. Gitu Muigai was my classmate, and we used to sit on the front line. I was never sitting in the forest. We used to sit together on the front line. So do you now agree that we can also invite him to come? Because I will just require a phone call. Is it okay? Yes. Then he mentioned the institution of the Supreme Court. One of the judges in that court, called Honorable Justice Smokini Wanjala, was my classmate. Did I mention that, my brother? Smokini Wanjala was my classmate. He used to sit at the back. And because he was left-handed, he used to say every time, "Iyo tumekata." And actually, my brother, we are soon inviting him to come. So please identify your classmates. When they do well, you feel good, isn't it? When Judge Smokin came here for the inspection, then he found that Moitu is the dean. He said, "Is there anything else we can do? The inspection, we have finished." Are you getting me? You feel good about your classmates. So once more, let's just have an applaud of a nice clap for our chief guest, then we hand over to the students. Non-stop, yeah. Okay. So you will permit me to hand over the mic to the Master of Ceremony. And our students, before I sit, I want to congratulate our student leaders and the organizers of this function for the cooperation we have enjoyed. And next time, I think we shall perform even much better. Thank you so much.
At the beginning of this public lecture, our Dean School of Law told you that the most important thing that you have to do in this public lecture is listen. And if you've listened, which I believe you've done, I believe that you've learned so much. And where there's a start, there has to be an end. And so I'd like to welcome our Congress School of Law to give the vote of thanks. Baraza, you're welcome.
Indeed, it has been a nice day. Let me invite Madam President to give the gifts, and she will assist me in giving the vote of thanks. Let us clap for her, Chikant. But now, before I do that, I would like to thank everyone that helped me and the administration in organizing this activity. We have tried our best. I hope we reach your expectations, and if we didn't, we will endeavor to do better next time. I would like to thank the ANC, Mr. Braxton Nicotieno. Let us take a moment to clap for him. This guy has done a lot today. And he whispered to me that he's vying for presidency of the society. I'm sure he has better things for you than I do. Let us clap for him again. Thank you very much. I'll, at this point, invite the president.
Thank you so much, Mr. Ongoya, for those powerful insights. I believe we will, thank you so much for challenging us. I think now we are going to look at things critically on matters, politics and the law. Maybe just to give a vote of thanks to everyone. So first and foremost, I express my deepest gratitude to Mr. Elisha Ongoya, our esteemed guest, for this thought-provoking address. Your insights indeed on politics and the law have enriched our understanding of its role in shaping a just and equitable society. So in case for the people, in the arena, what I'm basically doing is collect composure, and I just want to read. So Aristotle once said, at his best, man is the noblest of all animals. Separated from the law and justice, he is the worst. This reminds us that the essence of the justice is not merely in the written law, but in its fair and just application. Today we have discussed how judicial activism plays a crucial role in upholding justice, especially in times when legal interpretation becomes necessary to bring societal gaps. A sincere thank you to my organizing team for the meticulous planning and dedication, ensuring the smooth execution of this event. Your efforts behind the scenes have made this gathering a great success. To our distinguished guest attendees, your presence and engagement have added immense value to our discussions. Thoughtful discourse is the backbone of any progressive legal system, and your participation reflects a shared commitment to justice and fairness. I also want to extend my gratitude to the technical and support teams, whose hard work has ensured everything has run seamlessly. Last but not least, my heartfelt thanks to each one of you. Let us take this thing forward. The knowledge and the perspectives gained today, carrying with us the responsibility to uphold the ideals of justice and the rule of law. Once again, thank you, and all have a wonderful evening. Maybe just to present gifts to the speaker tonight.
Okay, can you stop first giving sodas? Those ones who are giving sodas. We are not yet done. Kindly. Kindly. Thank you. Thank you.
So I would like to present a few gifts to our speaker today.
Yeah, now that our guest today is a lecturer, we want him to keep a very nice diary so that the next time we're inviting for a public lecture, he will write it somewhere in that, right? Yeah? Yeah. And also I did a very nice research on the background of this man here today, and I noticed that he's a lawyer. So I brought a flask for him to carry tea to office. Yes, let us clap for him. Thank you very much for coming. Thank you very much. MC?
For our closing prayer, I'd like to welcome Griffins Momanyi.
Good evening. Let's be upstanding for a closing prayer. In the name of the Father, and of the Son, and of the Holy Spirit. Our Father who art in heaven, hallowed be your name. Your kingdom come, your will be done on earth, as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not to temptation, but deliver us from evil. Amen. Glory be the Father, and the Son, and the Holy Spirit, as it was in the beginning, it's now, and ever shall be, world without end. Amen. In the name of the Father, the Son, and the Holy Spirit.